Hi, everyone. Thanks for joining what I believe will be the last seminar for this year. This time, Dr. Toni Collins from the School of Law at the University of Canterbury will be talking about her work related to cordons. I'm really looking forward to this, as Flagship 3 has been struggling with the challenges around cordons and what are the factors that influence putting up a cordon, what are the impacts of cordons in recovery, and the whole legal issue around cordons is certainly an important aspect to that. With that, I'll just quick intro, I'll turn it over to Toni.
Oh, thanks, Ken. Oh. Right. Hi, everybody. Welcome to the seminar, Tēnā koutou, tēnā koutou, tēnā koutou katoa. As Ken said, my name is Toni Collins, and I'm working with John Hopkins as part of the legal team for the Flagship 3 in QuakeCoRE. And as part of that, we also have a disaster law team at the university, which comprises of about 5 of us legal academics. So we're looking at various things like Indigenous rights, human rights, and other topics around that in terms of disasters and gender. So today we're going to look at the law on cordons and how this is going to how can we use this law, or whether the law is effective enough to help us in terms of the research that we're doing, particularly around the Wellington scenario. So why is this research necessary? I thought I'd start off just giving a bit of context here and telling you a little bit about the research that I was doing for my PhD, which made the cordon law so important in this area. My PhD looked at what happened to commercial landlords and tenants in the CBD after the earthquakes. And you know that in Canterbury, of course, there was a large cordon set up. And this meant that a number of landlords and tenants could not access their buildings. Now, we know that the buildings were damaged and there was significant destruction within the CBD, but that didn't apply to all of the buildings. And so what happened when we set that cordon up around the CBD is that a number of landlords and tenants could not access their buildings that would otherwise have been usable and able to have been occupied. So that created a real legal problem for them. Their leases and the law did not provide for it. What were they to do? Do you pay rent for a building that you cannot access? And this was the problem that arose for these people. Landlords were saying, well, it's not my fault, we can't access the building, I've got one there for you ready and able to be used. I didn't set up the cordon, I've got my own financial obligations to banks and other things. And the tenants said, well, that's not what my obligations are under the lease. My point is I rent a building from you, I pay my rent, and I want to have a building to operate my business from. So this was a real problem in Christchurch, and I went and interviewed a number of landlords and tenants as well as lawyers, and it was a significant problem. Now, the reason you may not have heard of it so much, there were a couple of articles in the press about tenants having to pay rent for buildings they couldn't access, but overall, the only way that landlords and tenants can deal with any of these problems is through the courts. Most of the businesses in New Zealand are small to medium size, and of course they don't have the financial resources to take this matter to court. The other problem, and the other reason why they wouldn't want to go to court, so that we have not really got any case law, any precedents here in relation to this issue, is because the law was unclear. So the lease did not provide for the situation. It only provided for the situation where a building was damaged or it was just destroyed, in which case the building was untenantable. If it's untenantable, then you can terminate the lease. If the building was merely damaged, then the rent was abated until such time as the building could be reinstated. But we were in this sort of catch-22 situation where there was no damage to a building or nothing that would prevent the building from being used and occupied. Maybe there would have been some cosmetic damage, but that's not going to affect the use of the building. And so these people couldn't use the lease to terminate, and the landlords were not willing to let them terminate. I had one charity who paid rent for 8 months for a building in the CBD they couldn't use. I said, why? And they said, because we would rather have paid the rent than pay legal fees when we didn't know what the outcome of the case was going to be. It's going to be a lot more money. So this was a very real problem. It is still going to apply to Wellington. The reason for that is that even though the standard form lease that is commonly used in New Zealand was changed in 2012 after those earthquakes, the changes only apply when there's an emergency. Now, if you remember back to the Kaikoura earthquake in 2016, no state of emergency was declared because the city was adamant that they were not going to set up or stop the CBD from being used. We understand why those reasons are, and we'll talk about those more in a minute. But in that situation, the clause in the lease that allows a landlord and tenant to terminate cannot be invoked. There's another reason too, that the default period for invoking that clause is 9 months. Now you think about a dairy or a small business or a hairdresser or someone in the CBD, a smaller business, they can't wait 9 months of paying rent for 2 buildings. So again, still problems with the lease as it is at the moment, and that's more research that I'm looking at doing as in my sabbatical next year, I'm going to go up to Wellington and interview some more people. So that is just some context and background to why I've moved on to these, looking at cordons now and how we can use the cordons or the effect that they actually have on businesses in our cities. Now, also remembering that the cordon in Christchurch, of course, we shut down the whole CBD and it was in place for over 2.5 years. Now, that's an unprecedented response to an emergency in New Zealand. And in fact, I don't know that there are many other cities in the world that have been shut down for that length of time. Now, of course, as areas were made safe, the cordon was reduced over time, but there were still really significant issues with traffic movement around the city. And also you'll remember that a lot of people, they just avoided the city altogether. And so places like Northlands Mall, Riccarton Mall, they all were booming at that time because no one bothered, well, you couldn't get into the city. And so the businesses, even if they had been able to access their buildings and stay in the city, had lost a significant amount of foot traffic and people just coming for various reasons. One, because we had all suffered that emotional trauma from it too, and the last place we wanted to be was a place that had been badly affected by the earthquakes. Okay, so businesses, workers all relocated to the outskirts of Christchurch and set up businesses out there. The other thing I found in my research was that the landlords, of course, who were out in the suburbs, and if you remember, for those of you who were in Canterbury, that prior to the earthquakes there was a lot of empty space out in the suburbs, out in the business parks, and suddenly these landlords were having people hammering on their doors, wanting to find space. So, of course, being commercially minded, they locked people into leases that were a lot longer than perhaps would have been the case previously. So the standard sort of term of a lease is about 3 to 6 years in Christchurch, but they were locking people in for 10 years. And people were taking them up because they were desperate for space, and it became that, you just had to find somewhere to operate your business from. So now the other problem too, residents were really affected. And so what is this going to mean for Wellington? Well, unless we can keep some sort of access available and some sort of route through Wellington open, it's going to be the same scenario as Christchurch, and Wellington probably can't survive that. If you think that government, head offices, those sorts of things will move immediately out so that they can keep operating, but long-term or anything that's going to go on for a lengthy period of time is just going to shut Wellington down. So it's really essential that we keep it open. And we know that particularly Justin Lester, when he was mayor, was very aware of that fact, and which is one of the reasons why he did not want to cordon the property or actually shut the CBD down after the Kaikoura earthquake in 2016. And he preferred to just cordon individual buildings rather than shut the CB down. Now, of course, there's going to be a period of time immediately after the disaster where there's going to need to be cordoning, perhaps for assessing buildings. But I think if we can be as prepared as we can, which is what we're doing with our inventory in Flagship 3, and looking at the buildings and determining which ones are likely to fail in that Wellington scenario, and working out a route that we can keep open so that taking into account which buildings are going to fail. There will obviously be a period of time where we need to go through that demolition process, and so the cordon may have to be in a way that is flexible to be able to move with how that demolition process is undertaken. Now, of course, this all presupposes, of course, after a big earthquake, that there will still be buildings that will be able to be used and tenanted. And there will also be buildings that will be available for residential living, because that's the other thing. It's all very well to keep the city open, but we need places for people to be living. So that will also have to be taken into account. Now, in terms of going back to that example I gave you about the leases, one of the points in the lease is if a building is untenantable, then you can terminate your lease. So does an inaccessible building come within that definition? And that was something that I've looked at, and I can't give you an answer to that because we have no case law on it. The way that that word untenantable has been used, it's more about the use of the building for the purposes of work, as opposed to not being able to get into the building. But I'd like to do a little bit more work in that space. This is just developing research. So if we did get a case that said that an inaccessible building was untenantable, then that would enable people to terminate their leases and move out. But that is one thing that we will need to deal with in Wellington, is the buildings, the landlords and tenants and residential people will still be tied to their leases if they're not able to terminate them, and if their buildings are still okay and able to be used, but they are just inaccessible by virtue of a cordon or for some other reason. Okay, so let's have a look at the law on cordons. Now, there are two different ways that the law relates to this in two different situations. It has one law for when we have a state of emergency declared, as I mentioned to you before, and other laws where there is no state of emergency that's been declared. So there are a number of people who can authorise the erection of a cordon, and their powers are conferred by statute. So civil defence, local councils, territorial authorities, the Minister for Transport, police, health and safety inspectors, and other authorised people under things like the Biosecurity Act and the Fire and Emergency New Zealand Act are good examples. Now, when there is an emergency that requires more resources than what the local area has available, then a state of emergency will be declared. So it's likely to be up to the councils to decide that, as to whether they're able to cope, and the other, obviously, emergency response teams, as to whether they're actually able to cope with the emergency as it is. But once the state of emergency is declared, then the Ministry of Civil Defence and Emergency will become involved, and they deploy government resources to the affected area. Now, because actually declaring a state of emergency effectively takes the control away from your local councils and local territorial authorities, not always, the council are not always keen to do that, as we can see from the Wellington situation, because they lose control of the management of the emergency and the disaster. So that's why we have these different situations. Okay. So where a state of emergency is declared, of course, our governing act is going to be the Civil Defence Emergency Management Act. And under that, there are groups, and approved people in these groups can declare a local state of emergency. And of course, in order to deploy these resources, we need to declare that state of emergency. These people have wide powers to take action in an emergency, and included in those powers is the ability to cordon or manage access to areas. The only limitation on that power is that they must not do anything that's inconsistent with any direction of the minister or the national controller. Now, if there's a state of national emergency, then the Director of Civil Offence and Emergency Management has broad powers to act, of course, just like did in Christchurch, and they're also able to delegate them to the National Controller and the National Recovery Manager when there's in the transition period. Now, after the Canterbury earthquake, there was a review of the management, civil defence and management response to the earthquake, and the recommendation was that some guidelines be produced in relation to cordons in an emergency. They clearly felt that it was sort of done on a reactionary basis, and they needed more sort of guidelines and direction. So and also under the Canterbury Earthquakes Royal Commission, recommendations were put out under a heading of cordon management, and so these recommendations have now been taken up by government. Now, the recommendations were that the Civil Defence and Emergency Management should be responsible for setting up and maintaining the cordons during the state of emergency, and then the territorial authorities should be responsible for maintaining them at the end of the state of emergency until the public space or building they surround is made safe. Now, another interesting recommendation is that the territorial authorities should be able to recover the cost of maintaining any necessary cordons from the building owner after 3 months. So this, I think, is going to be some sort of incentive to get, particularly where the buildings need to be demolished or repairs need to be carried out, as an incentive to get the building owners cracking on with what they need to do. Right. So these guidelines for emergency management control. Do you mind if I just grab a tissue? I'm finding it really, really hot. Sorry, it's really, really hot here. Beg your pardon, everybody. Right, directions. So the recommendations have been accepted by government, and the Ministry for Civil Defence and Emergency have produced these guidelines that were published in August 2015. And they essentially are for the emergency management groups and agencies responsible for movement control in an emergency. The guidelines aim to orient the controllers and personnel about the considerations related to movement control and to enable them to direct the management of access along public thoroughfares and to and from property. Now, the interesting part for this for me is the fundamental principles that apply to these guidelines relating to movement control. The first one is necessity. So they've really drilled down here and said, what I've got out of it as an overview is that cordons need to only be put up for as long as reasonably necessary and for the purpose for which they need to be put up for. So to be very clear about that. So the first one is necessity. The need for movement control must be carefully considered before any measures are implemented, and advantages and disadvantages should be weighed against the necessity. Secondly, aims and goals. Movement control should always be aim or goal oriented, and there should always be trying to avoid unnecessary extended movement control. Continuity of public activity. Again, this is something I want to really keep in mind for Wellington. Movement control should try not to impede normal public activity as much as practical, helping to ensure a swift and effective response and recovery. Now, again, how do we do this? That's the important thing. Other ones such as rapid setup, using experienced personnel, communication, again, with stakeholders and the public. This was very poorly done in Canterbury. I had a lot of information from my landlords and tenants particularly, and from lawyers to say one of the big problems was information sharing between the parties. Not only were they not told how long the cordons were going to be up, there was just no information about that. And thank you so much. Or on the state of the on the buildings. I found that, for example, building reports were not passed on to landlords and tenants. They could not actually determine whether they were going to have to stay in their building or whether they should even pay rent. So, in terms of cordons, actually having the communication with stakeholders and the public, extremely important. Business as usual processes, trying to keep those going as well, but again, it's going to depend on the type of emergency situation we have, and definitely coordination between responding agencies is very important. So it is clear from these principles that there are a number of considerations that must be taken into account for decision-making around cordons. A strong feature is that they want to avoid unnecessary and extended cordons. Right, so the powers, there are a number of powers in the Civil Defence and Emergency Management Act that allow a controller or a constable, call them constables rather than police officers, or a person authorised by them to cordon an area. So, for example, they can evacuate or exclude people from a public area when, in their opinion, it is necessary for the preservation of human life. So this comes out quite strongly. And also they can prohibit or restrict access to a public place when it's necessary to prevent or limit the extent of the emergency. So they have these wide powers, as I talked about before, to cordon, to prohibit public accessing and exclude public from accessing areas. When there's a state of emergency declared, we also have these other documents such as the National Civil Defence Emergency Plan Order, and again this is for coordinating the responding agencies, and they will have powers in order to the various agencies to work with the cordons. And then Wellington has its very own specific National Initial Response Plan, and this is a supporting plan to that first one that I've talked about. So essentially these plans set out the responsibilities of the groups of responders such as civil defence, fire, police and military. Now, I've referred to this in our flagship 3 group, but the new amendments to the Building Act, which came in 2019, have now provided more law around managing buildings in an emergency. So they actually designate areas, and then once the designation decision must be in the public interest and necessary for the protection of, for those reasons there, to protect people from injury or death, buildings from damage, public thoroughfare from disruption, critical infrastructure, and also persons or buildings from the effects of if they're unsanitary. So if this is the case, then the buildings in the designated area are able to exercise powers such as entering buildings or land and take measures to protect people and keep them away from the buildings. So these are the powers they have. Now the paramount consideration, of course, is going to be human health and safety. And also one of the other principles for these is that they should result in minimal disruption or restriction of the ability of an owner or occupier to access their building and their land. However, again, as I say, it's going to depend on the actual specific emergency. Now, we move on to where no state of emergency is declared. So different laws apply under this situation. And this is where there may be the lacuna I was talking about. Because When we have a state of emergency, obviously there are wide powers to deal with cordons. Here, like in Wellington, a controller cannot direct or authorise movement under that Emergency Act because there's no state of emergency declared. But it can liaise with those authorised to deal with the emergency and doing the cordons under other legislation. So these are the acts that there are other abilities or powers to cordon under the Local Government Act, the Policing Act, and those, for various reasons. But again, limited powers, and they're more specific to the actual purpose of the Act as opposed to an emergency. Now, probably the one that has the most widely ranging powers is the Fire and Emergency New Zealand Act. So particularly down that second one, all things, they've got powers to close roads to traffic and people during an emergency and to do all other things that are reasonably necessary to protect and preserve life. Also to prevent or limit damage to property and land and to the environment. So they do have probably the broadest powers there. But the issue that I've got here too is how long do these powers go on for? We haven't actually got anything that specifically says that. If it's going to be for over 2 years, then are they still working or are they able to be used for that length of time? Local Government Act, councils can close roads as part of their general powers, so can the police, but again, as I said, more specific to the purpose of the Act, which would be things like when there's an accident or emergency in terms of policing. And finally, the Building Act, which I've already talked about, has been amended, but under the Building Act there are also powers of territorial authorities to deal with dangerous or unsanitary buildings. But under this, a dangerous building is one that's defined as that may cause injury to people, but excludes earthquakes, so that doesn't help us much. I think I'm running out of time to do a case study on Wellington, but I just can do a quick, I think I've talked about it as I've gone on anyway. And so the statutory powers that are given to individuals or agencies to make decisions about establishing a cordon will influence how effective a cordon is going to be and how successful it is. And Carolyn and Shatsi have said in their article that they recognise that the statutory powers vary in different contexts and therefore advocate that local emergency preparation plans should aim to identify the relevant people and organisations who have those relevant powers to establish the cordons to ensure that all of these people are working together. So having seen the changes in the law since the Canterbury earthquakes, shows me that there's still work to do in this space. Some work has been done, but all of these things are really interlinked, particularly when we're thinking about businesses, leases, and people living in residential accommodation, around how this is all going to affect them and how can we certainly have the powers to cordon in an emergency. How different is it going to be for us when there isn't a state of emergency declared? And how all of these things are going to affect these particular parties who are affected. If we do have the big one in Wellington, I would suggest that a state of emergency will be declared, so we will have those broad powers. So, yes, and just to finish, so my solution is that it's got to be a collaborative one whereby we can work out the buildings that are likely to fail, we can work out the way that we can set up cordons to ensure that access is still available to the centre of Wellington, and working with other agencies who are going to be able to set up, for example, the spaces for businesses and residential accommodation, because those are the two key things to keep the city up and running. And that is the end of my speech. So thank you very much. Are there any questions? Right. No.
Toni, may I ask that you repeat the question for those on the online?
Oh, sure. Yeah, I will. Sorry, can you repeat the question and I'll repeat it? It's difficult for engineers to decide whether a building is at risk. Does the earthquake sequence suggest that the cordon was required? I think that it was such an unprecedented situation that something had to be done urgently, and I think that was what I see Christchurch as being as a reaction to a situation. And so what I would like to see is us being the other way, being prepared and to know what's going to happen, and hopefully Canterbury's done that for us. I agree with you about how do you work out. I imagine that you've got, with the inventory and things that we're doing, as to what the types of buildings that may fail in an earthquake are going to give us an idea. Of course, you can't be certain. And of course, we've got the other problem too with Canterbury, as we know that the earthquake was not only a large earthquake, but it had certain features that was so different to what we may have expected in terms of the trampolining effect and all those other things. So how are you supposed to know what sort of earthquake we're going to have and how a building is going to respond to that? So perhaps the way to go about this is to be able to be flexible with our cordoning, and to be able to respond to different, not sure how we do this, but be able to actually respond to the situation as it occurs. So I don't think we can set up a specific plan as such. I don't think that would work, but being able to perhaps when the situation happens have the ability to make a decision at that point and say, right, the mapping system, this has all come down, and now can we see some sort of access route there? But it's all going to take time too. I'm not sure. Yeah. So you said if there's a very tall building, it's likely just to be able to be sufficient to have a cordon just around that one building. And that's, yeah. Oh, you've got the full shadow problem too. Yeah. Yes, yeah. Whereas we tend to cordon in blocks, or we have been, haven't we? Is there whole street? And thinking about the Reading Cinema in Wellington, what do you think about that, having to do that whole block for the one? Yeah. Yep. Yes. So the answer was there, what is the evidence of the risk, and are we being too conservative? That's right, and the law can only follow what we can only go on your scientific, what you tell us, where the risk is. So that's as far as we can go. But I think in terms of the law, the law needs to be flexible. Unfortunately, it's not always, but the problem we have is giving unbridled power to the government and others that will ride roughshod over property rights and individual rights, but allowing enough power to deal with the emergency at hand and to actually have the power to act swiftly. I think a lot of the problems in Christchurch were to do with insurance matters, so that certainly needs to be looked at. If we can get those buildings down more quickly, perhaps, and we know that they've failed and we can have them assessed more quickly, then maybe that would be an easier way to see a clearer way to keep the city open. Yeah.
Toni, may I ask if there's questions from people on the Zoom?
Yes, I do have a question, well, kind of a question and kind of a comment, because as you so nicely described, Toni, this is Caroline Orchiston, by the way, down in Dunedin, that there's huge complexity here, and it really, I end up chasing my own tail when I consider some of the potential outcomes of a situation in Wellington that we're going to face one day. And you noted also the role of insurers and how, you know, what lessons have we learned in terms of the rapid, well, it was relatively rapid demolition of some of the heritage building stock in Christchurch that some people considered was unnecessary. How do you think that's going to play out in Wellington in terms of losing buildings simply to try to get people access back into the CBD? Because as the Act says, that's a priority. We need to get people access back into places, public access. How do you think that's going to play out in terms of demolishing buildings rapidly, at times perhaps unnecessarily?
Well, I think that we've actually learnt a lot from Christchurch, which is the good thing. I agree with you. There were, I think because it was so unprecedented, parties took the opportunity of demolishing buildings if they could quickly before anyone realised what was happening. The example I'm thinking of is the one on Brougham Street. I think it was a church on the corner there. That was down within days of the earthquake. Other ones we've now learnt, you know, good examples of Christchurch Cathedral, how initially, very soon after the earthquakes, no one wanted that building up. And then as time went on and we had people who were fighting for it, it's turned on its head completely now. So maybe the heritage buildings is a real, difficult issue, I think. I think we do need to take time to think about the cost of repairing those, and obviously the value they hold for us. But in terms of keeping Wellington open, I think we have to make a value judgment as to what's more important. Is it keeping the city up and running, or can we do cordon it in a way that we can avoid those buildings? They can take time to have a decision made over them. I'm not sure what the answer is there, but it would depend on the event, I suppose, and that's why I'm sort of saying that we need to have a flexible law and laws in place so that we know what to do straight away rather than sort of reacting like we did with the Sarah Act and just giving unbridled power because we needed to move swiftly. So I don't think that really helps or answers your question, Carolyn, but it's certainly, if we've got, with the mapping exercise we're doing, I'm hoping we can identify those buildings that we may want to just cordon off individually and hold and perhaps sit on for a while until a decision can be made. Yes.
I think you've spoken nicely to some of these questions around what happens in the event that there is a cordon. I'm going back to some of what you was asking about, thinking of that balance and the judgment calls for the people who need to make a decision on whether to cordon. And it seems that consensus seems that there's potentially that Christchurch is felt to have been an overreaction. On the other hand, I can think of a scenario in Italy where spoken about and said the risk is not heightened relative to what it normally is, and some people did not act, and those people were taken forward when an aftershock did happen. So I wonder if you're able to speak at all to that balancing between, given the uncertainty that you have, liability for the workers, what needs to be considered in that aftermath?
Right, thank you. Good question. So the question is really about liability after an event. So if we take the risk that and keep the city open, and then there's another big aftershock and people are injured, buildings are damaged, what's the liability for that? Or are we very conservative like we were in Christchurch and cordon off 4 hectares of land to ensure that no one is injured? It seems to me the priority in the Act is about health and safety and keeping people safe. But, and Tim, I was just thinking about your point about were we too conservative in Christchurch? But if you remember, after September, there were certain areas that were cordoned off, but actually some argue that the cordons weren't big enough there, particularly down Colombo Street, where the buses were, and there was that horrible situation of the bus having masonry, maybe out from unreinforced masonry buildings. So some might argue that. Also, after the February earthquake, I believe in the June earthquake, some more buildings came down, and so had there been people in at that stage, there may have been a risk. But I don't know whether those could have been cordoned individually more so, as you say. So, yeah, I'm not an expert in that area. But yes, now in terms of your question about liability, in New Zealand, we have the ACC system. So any death or injury to people, if you make that wrong decision, is going to come down really to ACC. We're protected from that. However, I am about to embark on some research in relation to the Health and Safety at Work Act. Now, you know that this is a new act that's come in and puts a lot of liability onto people who are in control of buildings. And I'd like to know whether, if you have an earthquake vulnerable building, not necessarily under the Act, the Earthquake Prone Buildings Act, but an earthquake vulnerable building, so that's a building that we don't necessarily think is, well, it's not up to perhaps, well, we know there could be some issues with it, but it isn't something that has been highlighted as dangerous. Is there liability there for that from a person that's in charge of a building? Now, as the Act reads at the moment, you could argue that there is, but on the WorkSafe, who are the body who administer the Act, they have put something on their website that says it's not our priority to look at that at the moment. We're not going to prosecute for that. That's not to say they will never prosecute for it, so I'm just going to do a bit of research into that space and see whether, is that the reason that the council closed the library down, for example? Are they concerned about liability if somebody is injured in that library under that Act? Certainly not in terms of general liability, because we have ACC, unlike countries overseas that don't have it. Yeah, but it's a really good point, and I'm really interested to know what are the public authorities' liability, and one of my students has done a little bit of work in this area too around that, and exactly for that point that you made about the Italian earthquake. Yeah. How do decisions made by those in authority, and that may have an effect on other people, how are they liable for those decisions if we do take a more, I suppose, is it, would you class it as a higher risk approach to saying we don't know what the aftershock's going to be like? Maybe we won't have them, just like in Wellington, but we can't close a city down and destroy our lifestyle for a risk that we're not even sure about. How do we weigh that up? I think that'll be a question we'd all like to know the answer to. Yeah. Yes, good question. So when buildings are able to be used, and the question is, when buildings are still able to be used, who covers the cost of the fact that landlords and tenants or businesses cannot access their buildings? There doesn't seem to be any liability on the councils for that cost. That is a power they have to cordon. The councils don't have the power, but the emergency services, the civil defence and emergency, have the power to cordon, and under those emergency legislation, there doesn't seem to be any ability to compensate for those actions taken because they're doing it in an emergency. The insurers were pretty good in Christchurch. Most of them, insurance is key. It's absolutely key. And for the people that I interviewed, those that had insurance, or the employers had insurance, the building owners, it seemed to diffuse all the tension between the parties. For those that maybe didn't, Or the other problem was that the insurance may only have covered them for 3 months or 6 months, which is no good when you're out of the building for 2 years. So again, people have gone back and looked at how long is their loss of rent insurance for. And I think if we can get on board with insurers and get them covering this sort of thing, that's going to make a big difference. So generally insurance was okay. I was quite interested to note that they were pretty good about paying out for loss of rent when actually the contract or the lease contract said nothing about this scenario. So I think had they looked into it a bit more from a legal point of view, they may not have had to pay it out. So I'm just really glad they did. I was got to the point where I had to look at the doctrine of frustration, which is a common law doctrine that enables a party to terminate a contract where a supervening event comes in and affects the contract, so it's so different from what it started out to be. So I argued that could apply to the leases so that the tenants had the ability to cancel them. And I think had that been the case, then the insurers could certainly have argued that. But they didn't. So I think we're very lucky there, and they took a practical approach and just paid out for loss of rent when they could. But there were certainly situations where that didn't happen, and I think that was either where insurance was inadequate or, as I say, they ran out of their period of time that they had insurance for. Who would have thought that they would not be able to access the building for 6 months, 2.5 years, even when it was perfectly able to be used? So it was one of those situations no one foresaw. And even the lease didn't have anything in it, and the lawyers all rushed to the lease going, the lease is definitely going to cover this situation, where is it? And they were flicking through it, and they couldn't believe that it didn't cover it. So it was something that none of us had actually thought of, hadn't crossed our minds. So I'm actually doing some work with the Law Society at the moment about doing something about that lease and how do practitioners actually write into their lease or add extra clauses to cover these situations. Yeah.
Toni, this is Ken. I think we'll draw this to a close. I know this is a very interesting topic. When we talked about it on the Flagship 3 call, we ran long because everyone was so keen, and doing so again today. So thank you very much for sharing your experiences here. I wish everybody a restful and enjoyable Christmas break, and we'll have our next seminar in February.
Thank you, Ken.